I'd like to introduce our next speaker, Chris Benson. Christopher Benson is the managing attorney for the Monmouth County Office of South Jersey Legal Services, Inc., a nonprofit law firm dedicated to assisting low-income clients with free civil legal services. He has worked with SJLS since 2015, covering all of their civil practice areas, but with a focus on housing issues. He graduated from Northwestern University School of Law in 2013 with his JD, and from Vassar College in 2009 with his BA in Chinese and Middle Eastern Studies. And with that, Chris.
Thank you very much. Good morning, everybody. So, I think Brandon covered a lot of kind of the practical and clinical aspects of hoarding. My topic is going to be a little more focused, just kind of on specifically the common legal situations that we see a lot of our clients run into, and just got a little bit of information. So I work for South Jersey Legal Services. In New Jersey, there is a legal services office, sometimes multiple different agencies in each county. South Jersey Legal Services, Monmouth is South Jersey, not really, but we cover kind of Monmouth down, the 9 southernmost counties of New Jersey. Clients need to be income qualified, meaning that you either have to be under a certain income level based on your household size. We also have special rules for senior clients, meaning that you could be over income, but a senior and still eligible for services. And we always recommend people call our intake, even if we're not able to assist. We can often give a referral out. I also want to clarify that the information that I'm giving in my presentation, it is not specific legal advice for whatever your situation may be. I would encourage everybody, if you have a client or someone you want to refer to our services, please feel free to approach me today. I also have our intake information up here. But if you, during the Q&A, or if you have a specific case question, I'm going to ask you to hold off on that, because I really can't get into a specific thing. I can address things more generally. So hoarding is something that is not really, it's not directly defined in the legal areas that we deal with. And I'm going to be speaking mostly from the housing perspective, because that's what our agency mostly encounters, and it's often the direct legal impact of someone having a hoarding disorder. But there's nothing in the law that says, oh, it's illegal to be a hoarder, or if you are hoarding, we will evict you, or we will eject you, or whatever the case may be. Most commonly, and this is just because of the nature of our agency, we run into hoarding through the landlord-tenant lens. And the first thing that often comes up is the landlord will send a notice. A notice is a formal letter. It by itself has no power. You cannot, if you get a notice saying you got to get out of your house, that means nothing in the state of New Jersey. That is a requirement for them to file for eviction, but they cannot evict you themselves based on a letter. There are no self-help evictions in New Jersey under any circumstances. A landlord cannot directly evict a tenant. However, they can send them a notice. And a notice may say that you have violated your lease. There may be a provision in your lease requiring you to maintain it. There may also be provisions in your lease requiring you to maintain the community, or you may be in violation of someone else's lease if you're in an apartment block, let's say, and you've got a condition in your home that has spread beyond the home. So often this could be an infestation. Often this could be water damage or other kinds of damage that has spread to other units. But even if it's an individual apartment, an individual home, a condo that you're renting, that can still be a lease violation. As well, mold, very, very common, especially more, shore located units. There's already kind of a lot of water in the area. There's mold issues. Even in cases with houses without hoarding, if there is hoarding, there is almost inevitably mold in Ocean and Monmouth counties and Atlantic counties, especially because the hoarding issue will cover up areas that will then kind of grow mold. As well as I say here, cascading repair issues. What I mean by that is that if you are a hoarder, chances are there's other things that are going on where you're not paying very close attention to your home. So you may miss some damage. That damage can cascade into further damage, and a failure to report that by itself could be a lease violation. Basically, you've caused more extensive damage because you didn't tell the landlord at first, oh, there was a leak. Because the leak turned into water damage, turned into mold, turned into structural damage. And 6 months down the road, it's a very different kind of problem. Pets, just very specifically, we have encountered, not that commonly, but we have encountered clients where their hoarding issue is with animals. They have far too many animals. It's very common for leases to provide for 1 or 2 animals at most, and all of a sudden there are 7 cats and 10 dogs, and it is a lease violation. It's a health and safety violation. Fire risk, this is just kind of a general thing, but it speaks also to the cascading repair issues that I talked about before, where if you're not paying attention to part of your home, you may not be aware that certain conditions have created a fire risk, and fire damage is something that is an immediate lease violation, immediately evictable offense. It's a very common side effect of hoarding. Even if the hoarding itself doesn't deal with something that's specifically flammable, it can contribute to that. As well, the landlord-tenant relationship, something that we really focus on. Our office really focuses on eviction prevention, eviction mitigation. Often people call us with eviction situations that we can't fix, but maybe we can get them enough time to land somewhere. We can make an agreement with the landlord where there isn't an eviction on their record, even if they do end up having to leave. Hoarding can annihilate this relationship, even in situations where we've preserved the tenancy. If the landlord has lost all faith in the tenant to maintain the home, even if they haven't physically evicted them, they're going to make the rest of that tenancy hell for that tenant. It's not going to be good. And preserving that relationship is a surprisingly important part of the work that we do as legal services. It's not just you can live and survive in your home, it's that you can be comfortable there. You can know that if you call the landlord for, let's say that there is a repair issue that needs addressing, that the landlord's not going to just brush you off and say, well, you caused that probably because of your hoarding, because of your animals, because of whatever it may be. So the landlord-tenant relationship itself, even if there is no eviction, can be a direct casualty of hoarding. Fines. It was mentioned before by a question from the audience. Someone, an agency comes in and has to remove someone because the situation has gotten that bad. Well, a few steps before that, a lot of these code enforcement, construction agencies, municipal agencies can issue fines to landlords for violations if the tenant is responsible for the violation, which is not always the case, frequently is not the case. Frequently, it's a negligent landlord. But if the damage is from the tenant, the landlord has the right to pass that fine on to the tenant. There can be timeframes given by those agencies for the correction. There may be inspections required by code enforcement. It was also mentioned before by Brandon, and I'm glad he used that word, vouchers. If everyone is familiar, or if not, there's a number of different housing programs, most commonly known as Section 8, but honestly, there's a universe of housing programs that are out there that use vouchers. They give to the tenant, they can fully or partially pay for their rent. Those agencies do their own inspections. Those agencies can issue violations. Those agencies can terminate tenants off of these programs. So there's going to be some level of inspections and oversight where even if the tenant is on a recovery journey from their hoarding issue, even if they put in good faith efforts, they may need to meet certain legal standards from agencies that are disconnected from their reality of hoarding. There may be steps that they need to take to improve their situation, which are working and are getting them there, and they'll be there in 6 months, but they have to fix the issue next week. And that's actually something, if anyone has actually seen the show Hoarders, we have seen a number of episodes. That's commonly kind of one of the cruxes that's brought up. Is like, well, code enforcement needs this to be solved tomorrow, and we don't have time. Time is a huge, huge problem in these situations because often the mental health issue requires weeks, months, or years of work, and the landlord or code enforcement or whoever it is does not have that kind of leniency, may even be prohibited by law from having that kind of leniency. Our agency can kind of try to help bridge that gap and create solutions, but that's not always possible. Evictions. So it's great if a tenant calls us when they get that first notice. 90% of the time they call us when they get their court date. There's often a lot of time in between these things, especially for in New Jersey. If you're being evicted due to rent, your landlord is not required to give you any notice at all, unless you have Section 8 or certain federally subsidized programs. Outside of that, Rent evictions, your first notice is going to be your court date, and that is legal. That is how that works. Any other kind of eviction requires a notice. Even if you have burned down your house, the landlord is required to give you a notice to quit. 3 days, you got to get out. You've done something terrible, but you get a written notice. Often people call us way after that point. But technically speaking, even in severe hoarding situations, totally unlivable, landlord still has to serve a notice. If they do not do so, that eviction gets dismissed. The reasons, the plain legal reasons, like I said before, hoarding itself is not listed in New Jersey landlord-tenant law, but there are 2 provisions of New Jersey landlord-tenant law, and I brought them up here just to read them out. Damage or destruction to property. Now that's usually has to do with punching holes in walls, setting fires, things that are a bit more dramatic physically, but hoarding could lead to those situations. The other thing is health or safety violations or removal from the rental market. And that is usually when the town has noticed. The town has come in, has cited the landlord. The landlord, they may be passing on those fines. The tenant may be paying the fines, but those are still a basis for eviction. Depending on the severity, there may be a 30-day notice window where they give you a first notice called a notice to cease. That's your warning letter. If you don't comply with what's in the notice to cease after their time period, they give you a notice to quit. That is the end of that is what is legally sufficient. Now, after that, they might want to work with you. We could settle that case. We can figure it out. But if they don't want to, that is all the judge needs to issue an eviction. Timeline. So I put 6 to 8 weeks here. People always ask us, how much time do I have? It's very common in any landlord-tenant situation. Someone gets sued for eviction. They think their court date is the day that they're out. That is not true. The court date is the date when it is decided if they are out. After that, there's a time frame from there. But I put 6 to 8 weeks here because, typically speaking, once the landlord has filed, your court date will be scheduled within 5 weeks. After the 5 weeks, you'll get your court date. If you lose that day, you're going to be evicted in 2 weeks. And you can go back to the court and ask them for a bit more time, and they'll give you 1 more week. So 6 to 8 weeks is your worst case scenario for pretty much any eviction in New Jersey, not just related to conditions. But that's your worst case. Doesn't mean that it's going to be that quick, but it can't be, or sorry, it cannot be quicker than that. It can be slower, but it can't be quicker than that. Defenses. So the basic defense to an eviction related to hoarding is that you are not actually doing the behavior, or you've cleaned it up. So for example, landlord gives you a notice, says you have to clean this up, you clean it up. Landlord sends you a quit anyways. They said you didn't clean it up. Well, that's not true. Maybe they didn't even inspect, but you have to be able to prove that. You need to have receipts, pictures, whatever else. And that is also why I highly, highly encourage, if you have a client, you've got somebody in this situation where they are at week 1, call us week 1. Don't call us week 8, because week 8, we can't get photos. We can't go to your unit on the day of court and show the judge, well, look, it's all cleaned up, because the judge needs to have seen that it was cleaned up 7 weeks ago, not today. The notice to cease was the point at which you needed to clean the unit, not post notice to quit. This may vary by situation. These situations are very, very individual. So I can't speak for the judge or can't speak for all situations, but I can tell you that our agency has a lot more success keeping people in their homes if you call us at week 1, not at week 8. Municipal issues. So even beyond any questions of evictions, as once again as brought up before, if code enforcement in your local town or the construction department, some of them are organized a little differently. Every town works differently. But they absolutely can get involved in these. And sometimes they go after both the landlord and the tenant. Sometimes everybody is the problem. But you have a landlord not paying attention to their property, and you've got a tenant who has a problem, who's creating a problem at the property. They can issue fines. They can require court appearances. They can, as said before. Now, I said before, landlords cannot unilaterally evict in New Jersey. Judges cannot unilaterally evict in New Jersey. There has to be a hearing. There's a whole process. However, townships can. Doesn't happen all the time. And honestly, I would say the majority of the time it is not the tenant's fault. We run into a lot of, or at least that we've seen. Landlords, leave their property into disrepair. It becomes dangerous. There's a structural violation. Landlord hasn't updated anything in 15 years. Code enforcement finally comes and inspects. There was never a CO, and oh my goodness, like the floor is going to collapse. The tenant has to leave. And that's why they have the power to do that. But even in a circumstance where it's not the tenant's fault, it's crazy disruptive. And frankly, people who qualify for our services do not have the ability to find housing quickly. They do not have income. They do not have resources. They do not have networks that are willing and able to help them. And they don't have jobs that are flexible enough to let them move in the middle of the week because they got to go to work and they don't have PTO. Or if they had PTO, they had 3 days and they used it because their kid got sick 3 months ago. So these circumstances, even when it is not a hoarding situation, are often very devastating for tenants. That said, like I said, there are some remedies here. I mentioned before, there's some timelines. Usually if there's a first violation, if it's not so severe that they need to get out, there's an opportunity to remedy. There are going to be follow-up inspections. There's going to be oversight as well in circumstances where it is not the tenant's fault and they've been forced out of the home. The tenant has the right to seek relocation assistance, which is basically resources from the evicting agency to temporarily place that tenant. That agency can then go and collect that money from the landlord. Does this happen day one? Not always, frequently not. A lot of these agencies don't even know that they have a legal responsibility to relocate the tenants. Or if they know it, but they don't have the budget because they are just a guy in the municipal department, because that's how big that town is. So these things often, this is part of why we like to get involved early, because we can provide some of the advocacy to make sure that these transitions happen smoothly. Outside of the housing context, wanted to speak a little bit about this, and I just want to front here, our agency does not get involved with these disputes. We do not have legal expertise regarding questions of competency, questions of guardianship, questions of taking over legal decision-making for someone. But I wanted to address it because it's a big part of these things. So power of attorney, you probably have heard this phrase, you may not fully understand what it means. It basically is a legal document that you have where you formally give your decision-making capacity to another person. Now, these often kick in at certain circumstances. If you are incapacitated, if you have been deemed incompetent, if you are unconscious in the hospital, if something has occurred, a power of attorney permits somebody to come in and to tell the hospital, yes, they would like to be revived, or they would like care, or this person's out right now, but yes, we need to sell their home. We need to make other important decisions for them. A power of attorney, how do you obtain it? In advance. You cannot, once you are incompetent, this cannot be set up. You cannot consent to a power of attorney once you are incompetent, meaning that if you have a relative who has what you believe may be a hoarding problem, if you have a client who is in that kind of a circumstance, that person's mental health needs to be evaluated, because if they are beyond that point, you cannot set up a power of attorney for them because they have to consent to it. If they can't consent, you can't get a power of attorney. Questions about competency, especially in that specific circumstance. So you can go to court and try to get an emergency court order. It is difficult. It is not easy to do that. And there are so many for good reason. You don't want someone to be able to just go to court and get decision-making capacity for you. Like, that's a very, very serious thing to have someone suddenly in charge of everything in your life, including your finances. So doing it in advance, our agency, we do set up powers of attorney. I will say that. We don't get involved in the further disputes after that because that is beyond the resources that we have. And then finally, ejections. So ejections are different than evictions. Briefly, an ejection is for someone who's not a tenant. Most commonly seen, adult children. Parents want them out of the house. They refuse to leave. Parent ejects the child. Total destruction of family dynamic, as you might imagine. But that's the most common ejection that we see. However, situations with hoarding, if you have, let's say that you have invited a relative into your home and they have hoarded out your home. They do not own the home. They are related to you, or they are a friend, they are a guest, and they have overstayed their welcome. How do you get them out? Is via ejection. Now, an ejection is a very straightforward process. If you own the house and the person doesn't own the house, you can get an order to get them out. It takes about 2 months. It's a total court process. It's not quick, It's not 1-2, but there's no defense to an ejection. If you don't own the house, you do not have the right to live there. If you don't have a lease, you're out. But once again, the family dynamics involved in these situations means that this is often a very kind of last case scenario. And if you've got someone facing this, we can still try to get involved. We can still try to manage the situation, settle the situation, figure out a solution, because often the reason that they're getting ejected, sometimes it's, I mean, there's a lot of reasons that it can happen, but in the hoarding context, it is often directly and intrinsically related to the hoarding disorder. And so that's what we really want to work on in those circumstances. And once again, calling us week 1 versus week 8, getting us involved sooner rather than later, we can start to have these conversations. And even if it's not necessarily a legal resolution or approach, it's something that, you know, we can get involved with.
I'd like to thank Chris. Great job. Thank you.